This morning at 10:30 a.m., the United States Supreme Court issued a two-word order: application denied. This was not a ruling on the merits of a case, but a procedural termination of a final delay tactic. The court's unanimous, unexplained denial of an emergency appeal signals that the legal argument presented was deemed unworthy of even brief discussion. In the hierarchy of judicial responses, this is the most dismissive. The timing of this denial is procedurally significant. It occurred 72 hours after a key event, the filing of a proffer agreement by Melania Trump's legal counsel. A proffer is a formal preview of testimony and evidence a witness offers in exchange for prosecutorial consideration of immunity. The 72-hour sequence, proffer, emergency appeal, denial, is not coincidental. It represents a collapsing defense strategy encountering an immovable procedural reality. The substance of the proffer, as indicated by public filings, outlines three categories of evidence: documentary evidence, which includes knowledge and involvement relating to asset valuations, evidenced by signatures on joint tax filings, and documented presence in financial meetings; communicative evidence, which consists of records of discussions concerning valuation discrepancies presented to different institutions; and corroborative testimony, which provides direct confirmation of events and statements already given to the grand jury by other witnesses. The legal fulcrum is the voluntary waiver of spousal privilege. Under the precedent set in Trammell v. United States in 1980, this privilege belongs to the witness spouse, not the defendant's spouse. The decision to testify is the witness's alone. The proffer's inclusion of an explicit waiver indicates a strategic, voluntary choice to cooperate. This is not prosecutorial coercion. It is prosecutorial leverage derived from a witness's own assessment of legal risk. The defense's emergency appeal, filed within 24 hours of the proffer, argued that such testimony violated marital privacy. The Supreme Court's summary rejection indicates the justices found this argument to lack any basis in current law. To succeed, an emergency appeal must demonstrate both irreparable harm and a likelihood of success on the merits. The court found neither. With this denial, the procedural pathway is clear. The grand jury witness is ready to appear, as there are no legal barriers remaining. The prosecution is now in a stronger position with two options. They can use the testimony to strengthen existing charges like bank fraud and falsification of records, or they can seek a superseding indictment to introduce new charges, such as conspiracy, based on evidence of coordinated actions. The trial date is fixed, as major interlocutory appeals and privilege-based delays have been exhausted. This event sets important precedents. First, it shows that shared legal exposure in complex financial crimes can overcome marital privilege, even among the politically powerful. Second, the court's swift rejection of privilege claims signals that such claims will not be used as tools for delay when voluntarily waived. Lastly, it illustrates that the justice system can operate consistently, regardless of a defendant's political status. We have moved from legal theory to execution. The witness will testify, and the evidence will be entered into the record. The procedural challenges have been resolved, and we now face substantive ones. The Supreme Court's brief order confirms a foundational principle: no person or relationship is a procedural exception. The machinery of justice, once set in motion and free of obstructions, advances with decisive neutrality.
Question 1. What nutrient is most important for strong bones in older age? Vitamin D. Question 2. What is a good daily activity to keep joints flexible? Walking. Question 3. Which health check is essential after the age of 65? Blood pressure. Question 4. Which drink helps with hydration and health? Water. Question 5. What kind of food is best for heart health? Comment the right option. Question 6. Which habit can help prevent memory loss? Brain exercises.